Hi there. If you're watching this video, it is likely because you have an appointment upcoming to sign your estate planning documents. Assuming this is true, you should have received a PDF file by email that contains the bulk of the documents drafted on your behalf that comprise your estate plan. Hopefully, you can not only open that PDF to view the documents within it, but you're also able to navigate it officially by using the bookmarks feature. This is a type of electronic table of contents where you can click on the heading and be transferred to a particular document within that PDF file. If this doesn't sound familiar, if you're not able to open and navigate a PDF file, I'd be happy to send you a link with a very short video explaining how this can be done in relatively simple terms. The goal of this particular video is to discuss, one, some of the differing ways you can avoid probate, even without a trust. 2. Identify the major components of your estate plan and their primary purpose. This includes your trust, the certification of trust, your wills, and your powers of attorney for financial matters and for healthcare issues. 3. How all these individual documents fit together to accomplish their purpose, to create a disaster plan, whether that disaster is your untimely demise or it's a temporary incapacity due to illness or injury. And lastly, what you need to know, and more importantly, what you need to do to ensure your plan is successfully implemented when and if it becomes necessary. However, in the end, please remember that we are always here for you in regards to funding your trust and understanding what it is we've done for you and what your part therein is. And that's true whether it's next week, next month, or in many years to come. Typically, a primary goal of a client's estate plan is to avoid the probate process, an expensive and time-consuming affair that can be easily avoided with proper planning. As a review, probate is necessary when two things are true. 1, we have an asset that is titled in the name of a dead person. And 2, there is no non-probatable method of transferring that property upon the account or the asset owner's death. As a review, there are two common non-probatable methods of transferring property. The first is what we commonly call a beneficiary designation. Attorneys call it a payable on death designation or a transfer on death designation. They're all different names for the same thing. You advising typically an institution, a financial institution, of what you want to have happen to that account upon your death. It's almost certain that you have beneficiary designations on accounts as we stand here today. If you have a 401k, if you have an IRA, a 403b, when you created that account, it is very likely that somebody requested a beneficiary to whom that money will pass upon your death. And that was done when you created the account. Now, beneficiary designations work great if you are not worried about the beneficiary squandering the gift that you are leaving to them directly. In a beneficiary designation, they get a death certificate, they get a claim form, they mail it to where the money is being held, and they're going to get a check in the mail, or the account is going to be transferred to their name. And if you're okay with them receiving this lump sum with no controls on it whatsoever, then a beneficiary designation is a simple and easy, let alone effective way of passing property without probate. The other non-probatable method of transferring property that's typically used is a joint ownership with a right of survivorship. The instance here is a joint tenancy. If you are married and own your home with your spouse, it's highly likely that you either are a joint tenant or you have community property with right of survivorship. If one joint owner dies and there is a surviving joint owner, it passes probate-free to the surviving joint owner. And while this is fine between spouses, so long as they don't die together, or if one dies, then the surviving spouse then makes some sort of plan so that they have another non-probatable method, a way of transferring the property, or they put it into a trust. However, I almost never recommend using a jointly held asset, titling something between generations. For example, it would be rare that I would ever recommend to a client that they title their home in their name and their children's name just to avoid probate. There are many downsides there, and if you want to discuss those downsides, if you want to know what those downsides are, I'll be happy to tell you when we meet in person. If you own property where a beneficiary designation is not available, or perhaps suitable given the ages of your beneficiaries, then it's highly likely that a trust is going to be your best choice to transfer some or even all of your property. Keep in mind, this is not an all or nothing proposition. You can mix or match methods. For example, I have many clients with beneficiaries well into adulthood where only their home is titled in the trust, while all of their financial assets pass by way of a beneficiary designation directly to the kids outside of the trust, meaning the trust never has any role in transferring this property because the trust owns it or receives it upon your passing. On the other hand, I have many clients that have relatively young beneficiaries and they want somebody else to hold on to that money for the benefit of these beneficiaries for such things as their health, education, maintenance, support. And they want these distributions determined by the trustee, a trusted family member, a friend, whatnot. So therefore, the trustee makes decisions on what is distributed for the benefit of the beneficiary before they reach whatever age that entitles them to whatever is left over in their pot that hasn't been spent by the trustee for their benefit. In these cases, we tend to funnel all the property through the trust so that we have this power to hold on to these assets moving forward into the future. So, which methods you use will really depend upon your individual goals and how you want to best accomplish those goals. But chances are you'll use a number of these methods, non-probatable methods and the trust, to carry out your wishes. A trust avoids probate by owning your property so that if you were to die, well, we don't have property in the name of a dead person. We have property in the name of your trust. So therefore, it doesn't satisfy the first element to when probate is often necessary. With that in mind, it's really important for you to understand your role in making sure that your trust is properly funded, meaning your property is either in your trust while you're alive or it gets it when you die by way of a beneficiary designation so that it carries out your goals. Now, we're going to take care of any sort of real property you have in California, and we are going to take care of your stuff. We are going to transfer that to your trust before you leave our office, having signed all of your estate planning documents. And to be clear, when I say real property, I'm talking about land and things attached to land, like your house or a vacation home. And to be clear, when we're talking about your stuff, I'm talking about the things at your home, your tangible personal property like jewelry and furnishings and artwork. And their stuff is going to be transferred to your trust by way of what is called an assignment. It doesn't actually change the title. It just says it is your wish that these assets be property of the trust. You're never going to change title to your vehicles or to your boats or really anything that's registered at the DMV. The assignment will take care of that. So, beyond your California real property and your stuff, you may still have other property that you need to take care of when you leave my office. And this is probably financial accounts. And for purposes of funding, we are going to separate financial accounts into two broad categories. The first category is taxable accounts, just regular accounts that when they produce income, you pay the taxes on that income each year that it's produced by way of your income tax return. Then the second category is tax-deferred accounts. And tax-deferred accounts are things like IRAs, 401ks, 403bs, These types of accounts, they generate income, but you don't pay the taxes on the income until you withdraw the money. Typically when you're older than about 59 and a half, and typically your income has gone down so that your marginal tax rate is low to begin with. Now, let's talk about taxable accounts. They're easy. You can either change the title to the account to reflect the name of the trust, or you can leave it in your name and just make the trust the beneficiary of the account. Either way, it will either be owned by the trust while you're alive or get there when you die. And the trust will take that property and distribute it according to its terms. The second category are tax-deferred accounts. Tax-deferred accounts like 401ks, 403bs should always remain in your name while you are alive, giving the property away only by way of beneficiary designation upon your death. Typically, if you have a spouse, and of course if you want the property to go to your spouse, you will name the spouse as the primary beneficiary. And if you want that property to pass through the trust, then you can name the trust as the secondary beneficiary, the contingent beneficiary. That way, if your spouse predeceases you, then it will go to your trustee, and then perhaps your trustee will hold that money for the benefit of your beneficiaries and then make those distributions, as we discussed earlier, for the benefit of the beneficiaries, so they don't have that money to do with what they want. Quickly, I'll talk about life insurance policies. Generally speaking, for life insurance policies that do not have a tax-deferred component, which is pretty rare, then we just make the primary beneficiary the trust, so long as the trust is consistent with what your wishes are as to the distribution of that life insurance policy. Typically, this would be to your spouse and then perhaps to your kids. Either way, making the trust the primary beneficiary will make sure that we don't have a probatable asset should your beneficiary die shortly after you do, maybe from the injuries that were sustained in the same accident you're in. Because if your beneficiary, maybe your spouse, survives you even by a short amount of time, they become entitled to that money even though they die later before they have an opportunity to collect those funds. The insurance company is going to write a check to a dead person, and there will be no non-probatable method of transferring it. So we have an asset that is going to be probated, and if it's a life insurance policy, probably a pretty significant asset. Now, if you set these things up shortly after our meeting, it won't take much time. You just have to do it. And once it's done, it's done. You don't need to make changes as you proceed through life unless you acquire new assets. You create new accounts. And when you do those things, just set them up from the beginning so that they are titled in the name of the trust instead of your name as an individual, or you have your beneficiary designations as we've discussed. It's not going to take any more time when setting up that new asset to be in the name of your trust or to have a beneficiary designation to the trust than it would for you to have that in the name of your self as an individual. So the second document in your estate plan is your certification to trust. Your certification to trust is designed to give the third party, like the bank or the escrow company, information they legitimately need from your trust in order to conduct business with an entity, your trust. So, for example, let's say you go to the bank and you say, hey bank, I want to convert my savings account to the name of the trust so that it won't be in my name when I die with no non-probatable method of transfer. And they say, sure, we do that all the time. We need some information from your trust. And I would recommend that you give them the certification of trust instead of the actual trust document, because the actual trust document may contain the names and dates of birth of your children. It could contain information about previous marriages, adoptions. It could be who you are leaving property to and who you are not. And all sorts of other private information they simply don't need, in this example, at the bank. So the certification of trust is designed to give them that information they do need without giving them the information they don't need. And by law, they're required to accept the certification of trust in lieu of the original trust document. And in fact, if they don't do what the law says they're supposed to do, then conceivably they could be paying for your attorney's fees and costs to force them to do that which the law says they should do. The next document we're going to discuss in your estate plan is your will. Now, the unusual thing about your will is that we hope nobody ever needs to look at your will again after you sign it at our office. And that's for two primary reasons. The first reason is because the will is where you nominate guardians to care for your minor children if you're unable to do so due to incapacity or death. And obviously, we don't want to look to your will in addressing these types of issues. The second reason we don't want to look to your will is because your will gives away probatable property. And that's exactly what we're trying to avoid. So how might this typically arise? Well, one common example is the clients, years or even decades after they leave my office, decide to buy a different home. And when they acquire that home, they don't tell the title company to put it into the name of their trust. And time goes on and they die with property in the name of a dead person. Now, if it's not in your trust and we don't have a beneficiary designation, we have nowhere else to look to see who gets this property other than your will. Now, in this case, we don't repeat all of the distribution sections contained inside your trust as to who gets property and when. Instead, we just give the property to the trust. The beneficiary of the will is the trust. So in effect, your will becomes a safety net to make sure that your probatable assets pass according to your wishes as contained inside your trust. But like most safety nets, you don't want to have to rely upon them because there might be negative consequences. And those negative consequences in this case is the probate process and all the expense and time associated with that. So how do you avoid this result? In short, it's by understanding the principles we've been discussing and applying them as you move through life. Now, I understand I've given you a ton of information, and you may not remember all of the details in a month, a year, let alone a decade. So if you can just remember that I am always available to answer your funding questions whenever they may arise in an effort to avoid ever having to look at your will to determine where your property goes upon your death. The next set of documents we're going to look at are your powers of attorney. Powers of attorney allow somebody to act that you nominate when you're unable to do so yourself. They're supposed to act on your benefit. There are two broad categories of powers of attorney. One, healthcare, and two, property management and financial affairs. Your healthcare agent is entitled to request treatment, deny treatment, seek second opinions, access your medical records, talk to your treating physicians, and they're also empowered under certain circumstances to remove you from life support. Under the current Advanced Healthcare Directive that you're going to be reviewing, the agent can remove you from life support if 1, we are artificially delaying your moment of death, 2, you are in a persistent vegetative state or a coma by which you are unlikely to regain consciousness, or 3, the burdens of treatment outweigh any expected benefits. For example, we can keep mom alive, dad alive for another 3 months, but in order to do so, they are going to be in great pain, they're going to be in a respirator, and they are never going to leave this hospital room. In that situation, we may say, hey, the burdens of treatment far outweigh any expected benefits, and thereby you have the power to remove this person from life support. The second power of attorney is what I call for property management and financial affairs. I also think of it as your catch-all type of power of attorney. So if you're incapacitated and the asset that needs to be dealt with is a trust asset, then your trustee can deal with that arising from the authority given to them from the trust. And if it's in regards to your health care, then your agent under the healthcare directive can make decisions based upon the powers they've been given by way of the healthcare directive. But chances are, if you're incapacitated for any period of time, you are likely to have matters that need to be addressed beyond your trust assets and beyond your health care. This could be contacting your employer to be able to get your final paycheck, or filing a disability claim, or contacting the retirement company, or filing a medical insurance claim or an automobile insurance claim because the source of your injuries, your incapacity, is due to an automobile accident and we want to get the car fixed for you. Or maybe it's as simple as calling your utility company and finding out the account numbers and how much is owed, so when you get home from the hospital, you still have utilities. Now, all of these powers of attorney give your agents broad powers. You need to select people that will, live up to the trust, the faith that you have put into them to be able to carry out your wishes in your best interest. These documents, your trust, your certification of trust, your wills, and your powers of attorney comprise your estate plan, your disaster plan. And hopefully, these are precautionary and never need to be used until the moment is right. But if you do, it's good to know that you have this in place. But you need to remember that you have some responsibility in making sure this is carried out to your satisfaction. So if you have any questions, let us know. We'll be happy to answer them, whether, again, it's the day of signing or the weeks, months, or years thereafter. I really appreciate you watching this video. I hope that you have found it informative and helpful. I look forward to talking to you soon. Until then, be well and stay safe. Thank you very much. We'll talk to you soon.